The Faragher vs. City of Boca Raton legal case. Summary of the case. The example under consideration is Faragher vs. City of Boca Raton, which had been made a decision by the Supreme Court of the United States on June 26, 1998. It entailed the use of Title VII of the Civil Law Act of 1964, which brings up that any organization is responsible for managing workers creating a hostile work environment through sexual harassment. The Supreme Court held that the opportunity was had by the company to make an affirmative safety. In such a way, the selected case involves civil rights issues and their consideration. Beth Faragher is the complainant of the case, who worked for the city of Boca Raton, Florida, as a lifeguard. She experienced harassment and offensive sexual comments from her male supervisors. For this reason, she filed a suit under Title VII, claiming that workers cultivated a hostile work environment through their actions. Boca Raton City became associated with the cost of the process and possible damages. Introduction. Case. Faragher vs. City of Boca Raton, 524 U.S. 775, of the Supreme Court Reporter 2275, 1998. Facts of the case. She is the complainant in this situation, who worked for the city and experienced sexual harassment from David Silverman and Bill Parry. She reported that they performed the following undesired actions: offensive speeches, commenting, touching, joking, and hints with specific sexual context. Her female colleagues reported they had similar experiences interacting with Parry and Silverman. It proved the topicality of Faragher's complaint and the severity of the case, and regular violations of basic human rights were observed. And Faragher claimed that comments, actions, gestures, and offensive words are unacceptable as they violate her fundamental rights regulated by the Civil Rights Act of 1964 and discriminate against her regarding gender. The state must also be in control of the staff members of its. The district court ruled that the city was responsible for Parry and Silverman's misconduct. The Court of Appeals supported the ruling, as Parry and Silverman violated employment terms. Boca Raton can't be held accountable for negligence by falling short to take out such actions. Story. The Federal District Court agreed with Faragher's arguments and ruled in her favor. The city could litigate further. The 11th Circuit Court of Appeals refused to impose liability on the city. The U.S. Supreme Court overturned the previous ruling and agreed with the Federal District Court's conclusion. The case resulted in the emergence of the concept of the Faragher affirmative disease. It is used by employers to avoid vicarious liability linked to harassment claims against employees hired by them. Employers should create an environment favorable for employees and help to avoid sexual harassment. Legal questions. Following Title VII of the Civil Rights Act of 1964 linked to the sexually hostile work environment created by supervisors, can an employer city be held vicariously liable for its employees' actions? Decision on holdings. The court supported Faragher's claim and ruled that Boca Raton City should be held liable for the sexual harassment associated with its employees. Most arguments offered by the complainant were accepted and used to draw a final conclusion. At the same time, the court stated that the city should not be considered liable for failing to prevent sexual abuse or gender discrimination scenarios and situations. Verdict and opinion. Justice David Souter offered the opinion, assuming that the case can be viewed as the opposition between the traditional view on discriminative actions made by supervisors, and a new perspective, stating that such actions should be controlled by employers and considered as a part of their responsibility. Justice Thomas offered the dissenting option, saying the employer cannot be considered vicariously liable if employees cultivate inappropriate working conditions and fail to follow the major rules. Rehnquist, Stevens, O'Connor, Kennedy, Ginsburg, and Breyer supported Souter's opinion. Scalia was the only justice who supported the dissent. Conclusion. The court ruled the business must be held accountable after Title VII of the Civil Liberty Act of 1964. the city has really not been equipped to demonstrate its attempt to control the behavior of the supervisors of its to guarantee that females can definitely feel secure as well as value their fundamental civil rights of theirs. The conclusion created the basis for other citizens to address the court attempting to protect their basic rights and ensure there are no harassment or sexual abuse cases in their work.